1990, so quite a while. So I'm glad you're all here today. I hope you're having a good convention. Before I get started, since I'm familiar with California law, some things will be, I'll try to make them as general as possible so they apply to your states as well. But just so I have an idea, how many of you are from California? Pretty good showing. I know you two here are from Texas, so anybody else from Texas? Oh, that's a pretty good group. And some other states, you can just call them out.
Pennsylvania.
Oh.
Washington.
Good.
Missouri.
Wow. So we have a good, what was that?
Illinois.
Illinois. Good.
Arizona.
Canada. Oh.
Hey, that's not state.
It's close enough. So anybody else from outside the United States? Utah.
I agree.
She never was very good.
I know where you went. So, not really in this order, but the title of the presentation is Advanced Directives, Estate Planning and Legal Issues. It's important for everybody, but when you're suffering from medical conditions and you don't know how things are going to go, it's really important that you get these type of things done. But when we get started, we're going to start. I guess ask another question. How many of you have a will or a trust at this point? Oh, very good, very good. So you may know some of these basic terms, but it never hurts to go over them again. Like in a while since you looked at your documents, and it's a good thing to do. So first we'll start with a trust. A trust is defined as a management device for holding and managing property. We'll talk more specifically in a little bit. In the trust, you have a trustor, a settlor, or sometimes it's called a grantor, and that's the person who creates the trust. So if you have a trust, you're the one that created the trust and whose property is used to fund the trust. Beneficiary, that's pretty self-explanatory, but it is the one who benefits from the trust in the case of a trust. Funding, this is an essential, very essential, I mean they're all essential terms, but this is an essential part of a trust because without putting assets into the trust, there is no real trust, it's just a document. So that's the process of which you transfer title to your assets to the trust. So a lot of you are probably already familiar with these terms, but like I said, it never hurts to go over such things. And there's different types of trust. There's a living trust, which most of you have probably heard of. And that's any trust that's established, funded, created, and in effect during your lifetime, or a trustor's lifetime, the creator of the trust. A testamentary trust is one that's intended to take effect after death. There's two main ways that these are created. They can be part of a will, or they can be included as a subtrust in your regular trust. The will, including the testamentary trust, at least in California, is much less common than it used to be. Back in the day, trusts were only for very wealthy people, and a testamentary trust was a device to allow a measure of control for somebody that needed control over assets after death. Since the living trust has become in more common use, that it's less used, although you do see it once in a while. The main type of trust, which many of you, if you have a trust, probably have, is a revocable trust. And that's just a trust that can be revoked or amended or changed during your lifetime. I say yours, but I'm assuming it would be your as a trustor. It becomes irrevocable when the creator of the trust dies. And I'm just going to add to that. There are instances when revocable trusts become irrevocable during one's lifetime, and that has to do with capacity to the point that you're not able to understand what your estate is, what we call natural objects of your bounty. Generally those are family members like children, grandchildren. Doesn't have to be, if you're involved with your church, they would be maybe considered a natural object of your bounty. So even people that have some capacity issues can oftentimes still be able to create a trust if they understand those differences. Most of the time in California, if there's a spouse or domestic partner, they usually establish a joint trust. There's some reasons why you may not want to do that. If people have separate assets, things like that, you may want separate trusts. Most of the time, they have joint trusts. I'm just going to go back for a second. With the spouses and domestic partners in the joint trust, typically they're both co-trustees during their lifetime until one either passes away or if they're incapacitated, the other one will continue as trustee in most cases. If anybody has minor children or they're taking care of minor grandchildren, they're very important provisions that should be in the trust for minor children. They should have a nomination of a guardian of the person or the estate, and that would be after whoever is taking care of them now, whether it's a parent or a guardian. A trust, and this is applicable whether you have a minor child under the law, which is age 18 in California. I think most states are probably 18. A lot of people don't want an 18-year-old to inherit, a considerable amount of money or any chunk of money. Not that they're still not a beneficiary, but you may want them to wait for a different age. Typical in my practice, it's either 21 or 25, something like that. Sometimes people will say, oh, they can have $5,000 when they're 21, they can have this much later on, something like that. So those are things that are important to consider. And if there is no provision about guardians of a person in the estate and there is no living parent that's entitled to have custody of a child, then the court decides who that person could be. So it's a way to keep things out of the court, which is always a good thing. And so nominations avoid family conflicts and avoid that issues that go with that. So another type of trust is irrevocable trust. And irrevocable is, once it's created, it's not revocable, except under certain circumstances. But the trustee has to be someone other than the person that created the trust. And the most common reason is Medicaid planning. The program in California is Medi-Cal, but Medicaid planning, some irrevocable trusts will help you hold on to assets while still qualifying for certain public benefits. Healthcare is expensive, and you can use up assets, and if you've got a spouse or another loved one that you want to continue to provide for, you may have a need for irrevocable trust. Now, sometimes things don't work out well, and the only way to change an irrevocable trust is to go petition the probate court in California. But a trustor, a trustee, or beneficiary can petition the court to make a change or to revoke the irrevocable trust, but there has to be good cause. Usually it's some unforeseen circumstance, something like that, where it's just not going to work in the irrevocable trust. Occasionally, it's because the trustor, the creator of the trust, didn't really understand what the parameters of an irrevocable trust were. So that's that. There's also an irrevocable insurance trust, and in that case, it's established during the lifetime of the insured, and it's a purpose of owning a life insurance policy. So the trust is the owner of the life insurance policy. Some states, especially if you have a lot of medical bills or things like that, can have assets, but they don't have a lot of liquid assets. So that's a way that sometimes people have for paying for like burial expenses or after-death expenses or payment of any expenses actually that occur after death. And in this case, the trustee can not only not be you, it can't be a member of your immediate family. So that doesn't mean that they can't be like a distant relative, or typically people contract with a private fiduciary, which is a professional fiduciary licensed by the state and bonded. to handle those things. And another example is like a bank trustee or a corporate trustee. Now, the special needs trust is a very good vehicle for people with special needs. Sometimes they're called supplemental needs. And it's created for somebody with special needs, and the needs can be physical, mental, emotional needs. And it's for people that either receive public benefits or would like to qualify for public benefits. And it's a very good vehicle because it really shelters those assets. And the other part is public benefits are intended to pay for your necessities like food, clothing, shelter, and medical care. The special needs or supplemental trusts are not supposed to pay for those things. They're supposed to, I call it the fun stuff. Like I have a client, she has a special needs trust, and she got an inheritance that went into the special needs trust, and now she's an artist, she would like to go to Europe and go like to Florence, Italy, and the places where the great artists were from. Well, the special needs trust can pay for that, and that's not something she could afford on her public benefits. So that's a big example. Sometimes it's just little things that people can't pay for that can be helpful for that. Public benefits include Social Security, like SSI, housing, Medi-Cal in California, but any Medicaid program, food stamps, and then there's certain state and federal disabilities that are needs-based that are considered public benefits. And one thing that happens in special needs trusts that's often overlooked is that the beneficiary of a special needs trust still needs their own estate planning, whether it's a will or a trust, whatever is in their best interest for their situation. Okay. So the special needs trust can be revoked by the person that created the trust. And the trustee, usually the trust itself will have all these terms, but the trustee themselves can terminate the trust under certain circumstances. The most common reasons are the beneficiary doesn't need it anymore, for whatever reason. And another one is that, the principal in the trust is so low that they're able to distribute it to the beneficiary without affecting their public benefits. So those are usually the two top reasons on that. There's two, within the special needs trust, there's two kind of subtypes, I guess. The first one is a third person special needs trust, and that is funded with assets of a third party to benefit the beneficiary. So for example, someone, let's say, created a special needs trust for your husband or your wife or your child, that maybe has the same disease or has some need, some special need, and that's what a third party one is. It can be created during one's lifetime, by the trustor's lifetime, or it can be part of your estate plan to be funded on your death. So either way. And it can be established for a beneficiary of any age rather. So whether you're, just born, or at the end of life, it can be created. The other type of special needs trust is a first person special needs trust. That's where you create your own special needs trust, either to shelter assets or to maintain your eligibility for public benefits. And in my experience, the most common sources for someone to create their own first person special needs trust is an inheritance, an unexpected inheritance, or unexpected, but you're actually getting it, and a settlement from a lawsuit. So sometimes those are big settlements and would definitely disqualify you from public benefits. And a first person special needs trust can only be established by someone that's under 65 years old. But there's other ways that people over 65 can have a special needs trust as well. We'll get to that. And the first person special needs trust can either be established by the person themselves or by a court order if somebody doesn't have the capacity to do that themselves. Like if they are so physically unable to, or mentally unable to, or emotionally unable to understand the creation of a trust, then a relative, or we call them interested parties, so it can be a relative, a very good friend, somebody like that can petition the court so that they won't get this inheritance or whatever is coming their way and then disqualify them for their benefits that they're entitled to. So I mentioned that people that are over 65 have a vehicle for creating a special needs trust. The vehicle is called a pooled income trust. People that are under 65 can also use the pooled income trust, but this is one for people over 65. And it's a trust that's administered by a nonprofit organization, is what my bullet point says, but it's a nonprofit organization that's set up specifically for administering nonprofit organizations. In California, there are many of them, and I usually suggest to people that they kind of, interview them or have their attorney interview them and kind of, decide which one looks like it works for you. And the way these work is there's all sorts of people that need a special needs trust that are in the pooled income. But your account, if you were a beneficiary of a pooled income trust, you would have your own separate account for your own expenditures, your own money. And but the benefit is, of course, is they can use all these funds and are able to invest them properly for you. There's a lot of oversight for them, so it's not like you're giving the money to some unknown people. There's a lot of accounting required by them. It's just a really good vehicle in some cases. And these also can be self-established if you're able to do it yourself, or it can be established by a court order. And some of you, of course, know what a will is. I think most of you do, but I thought it wouldn't hurt to go over these. Whoops, it's going on its own. It sets out the will of your wishes, called the will of the testator, for his or her estate upon death. It nominates an executor and an alternate executor, and it's probated after death. You'll hear sometimes people say, oh, well, so-and-so died and the executor is doing this and the executor is doing that. Well, the executor has to be appointed by the court. It's just your wishes about who you want to have appointed by the court. So that's kind of a difference with that. This kind of gives you an idea. I'm a big proponent of trust for most people. Oops, why is it? I don't know why it's doing this. Let's go back. So this is California. Every state has its scheme of how attorneys and the administrator or personal representative, administrator if there's no will, executor if there is a will, how they get paid. Well, this is California's scheme. Many states it's an hourly rate, and those can add up. But this is how they compute it in computations in California. 4% of the first 100,000, 3% of the next 100, 2% of the next 800, and 1% of the next 900,000, and then above that it's like 0.5%. But this is what it works out to in California. And the figures on your right are, oops, it keeps wanting to go to the next, I'm not doing it. Those are per person, so the executor and then the attorney get. So when the first one, if the estate has and this is also, California bases it on gross value of your estate. So if you have a home, let's say, and there's a mortgage, the mortgage doesn't get taken off. So let's say the home is worth $250,000, and you have a mortgage of $250,000. Well, for probate purposes, it's still worth $250,000 for calculations. So the point of this is show you it adds up. Like this kind of stuff is expensive. And probate in California, and I just had some experience with a client who has a relative die in Pennsylvania, so I actually have a little bit of knowledge about Pennsylvania now. But both of those states have very different procedures, but it takes a lot of time. It takes a lot of time. Typical probate in San Diego is like 1.5 years, and that's if there's no problem and property sells right away, or there's no property to sell. They can take 2, 3, settle, so.
Why?
Well, a couple reasons in San Diego I can speak to. In San Diego, San Diego's pretty, I don't remember how many people we have. We have a lot of people here. And there are 3 probate judges in downtown San Diego for the entire county. And until, I'd say, the end of last year, end of 2016, we had 2 probate judges. So we're just added one, and he's kind of on the learning curve still. So even just the scheduling takes a long time. And there's always these things you have to do in probate. You have to inventory and appraise the property, and you have to file that, and some of it has to be done by anything that's non-cash has to be done by a court-appointed probate referee, who, guess what, he gets paid from the estate too. It's very time-consuming. So part of it is the fact that we need more judges in the court. Okay, so this is a very different type of, oh my goodness, why does it keep doing this? This is a very different type of will. This will is a pour-over will, and this one goes with your trust. It's designed to work with the trust, and it avoids probate. The way it does is literally pours over, you know how if you own a house or car, or you have your checking or your bank account, you can change title on that if you want. You can go to the bank with your trust and say, I have a trust now, and they will title the account in your name, your trust. You can have a deed prepared and file a deed that says your house is now in your trust. Same thing with your car. You can do that as well. But there's lots of things that people have that you can't do that. Jewelry, heirlooms, furniture, anything like that. So that, and occasionally, there are other vehicles that sometimes you have to use, but occasionally people forget to put something in a trust. And even if you have to go to court because it's not clear, if you can show there's a pour-over will that says everything's supposed to go in the trust, then you're one step ahead. So in California, and most trusts that I've read from other states, they seem to be accompanied by a form of a pour-over will. So that's another important document. Just need to set up something here. Sorry. So next, we have a power of attorney. Oops, not that fast. Okay. And this is a financial power of attorney. Some of you may already have one of these. This grants to a trusted individual, usually between spouses. It's between spouses, and then you have an alternate sometimes, if you want to. And they can transact financial, legal, or other transactions on your behalf if you're unavailable or incapacitated. And it's only effective during one's lifetime. So sometimes we do powers of attorney for a particular transaction, and I'll be talking more about that. Most of the time people do a power of attorney to cover all transactions. I always advise people, while they're still able to execute a power of attorney, to hold on to it. Tell that trusted person you have it. If it's a spouse, they would know that you have it and it's there. But you don't really need to use it most of the time until it becomes necessary.
Do those generally have a time limit on them?
I'm going to get to that. Yeah, good question though. Yeah. So we have a non-durable, a durable, and a special or limited, and a springing power of attorney. Uh-oh. No. So the non-durable is exactly that. You can put it for a certain length of time for some reason. The durable is effective until you decide you don't want it anymore and you revoke it if you do. And the special or limited is the one for the single transaction, like I'm going into the hospital and we're selling our house and I want you to be able to sign the paper so we can, and sometimes you have to do that, well, actually all the time you have to do that, even with your spouse and even if you're both on title, because if the one can't sign, somebody has to sign for them. So you can use it for that. And the springing power of attorney literally springs into effect when a certain event occurs. Or a date, but it's usually an event. Usually it's an illness, gets to a certain point, like, your illness, or maybe, something occurs, or you think it's going to occur. Sounds like that would be ideal, but there are drawbacks to the springing power of attorney. One is that it's not always like clear when that event is, or maybe somebody is incapacitated, but it's not from the event that they thought it was gonna be. You know, there's things like that that come up. So they're useful, but you need to be a little careful with those. Okay, so we're getting to the advanced directive, which is very, very important. Sometimes in some other states they call them durable power of attorney for health care. And these are the ones where you appoint someone to make medical decisions for you when you can't do that. In my experience, most people will make that their primary physician's determination. Like when that physician determines that you can't make decisions, then the power of attorney or the health directive comes into effect. And that's usually good because the primary physician, as you may or may not know, is not only your primary doctor, but if you're hospitalized, it's the hospital physician is your primary physician at that point, you know, because they're the ones that are managing your care at that point. And then again, like I said, it's when the individual is incapable of making decisions. And they can and they should include end-of-life decisions. End-of-life decisions can be included in the advance directive and or your will, but they should be included somewhere. A lot of people these days have pre-planned, you know, prepayment end-of-life, you know, with a funeral home or a cremation society or something like that, which is great, but somebody still has to have the authority to say to the funeral home, you can pick up the body, or you can do, you know, you can act under this. So that's important. Now if I have, oops.
You have to have that directive before, you can't just say husband?
Well, I don't know. I've seen it, I've heard of cases, I'm talking funny. I've heard of cases where, yeah, that's fine. Like the spouse just says, you know, this is what he wants. Sometimes they don't know, though, exactly, like, well, we talked about it, but I'm not really sure what he meant, you know, those kind of things. When I do an advance directive, I also put any wishes that people want, and I've had everything from no other wishes to like 3 pages of how they want their memorial service to go, what songs they want at it, so very detailed, you know, where, you know, half my ashes are to go here, and half, you know, that very detailed, to like, you know, to nothing, like basically nothing. Whatever my wife wants, whatever my husband wants is fine with me. All sorts of differences on, usually include, in California, your driver's license includes, you know, if you're an organ donor, but I always include it in the advance directive as well. You can, I've had quite a few people say they want their bodies going to science and things like that. So you can really kind of tailor it to what you specifically want and how, you know, people, the 2 end-of-life decisions are, you know, I don't want to be kept alive by extraordinary means, or, you know, within the medical limits possible. I've had quite a few people that are very strongly in favor of one or the other. I mean, it's surprising. You know, people are very, very committed to one or the other. So, you know, it's important, even if, you know, spouses have discussed this or family members have discussed it, to kind of put it in writing so everybody's clear. Sometimes there's sad cases where the husband and wife do know what each other wants, but, you know, maybe some adult children are questioning, well, I don't think Dad would ever have wanted that, or this one didn't involve a living parent, but I had a case that actually went to court. I had this on occasion. I call them the angry beneficiaries, and that's where you got one guy in charge of the trust and everybody else on the other side. And you know, the 3 were claiming the mother did not want to donate her eyes, but there was nothing in writing to say that she didn't. And the one in charge had the authority, and he just made a snap decision, like, sure, take her eyes, you know, like, you know. So that caused a tremendous upset in the family. That wasn't why we went to court, but, you know, that was kind of an idea of things that can happen. So that's basically everything. I'm hoping you guys have questions for me, so let me know.
If you do have questions, would you please keep your voice up or ask for the microphone? So this is being recorded, and it will be on the website, so the quality of your voice will carry over to the recording.
So you leave the
money or the property, do they get hit with heavy inheritance tax?
You know, it depends on the asset. One asset that does get taxed, and it'll seem really obvious when they tell you, like a lot of people have an IRA, sometimes they don't name a beneficiary. It's advisable from a estate planning point not to name your trust as a beneficiary because there's a higher tax rate. But if you name, like, let's say you name your children as the beneficiary after your spouse, because, you know, then taxes have to be paid normally before it's distributed, unless they roll it over, you know, they can roll it over into their own IRA. Some other assets will come tax-free, though.
And if they sell your property and whatever else you got.
Could you speak up so everyone can hear?
Repeat the question?
Well, yeah, he's asking if, you know, like this would be after death, if they sell the property, and do they have to pay taxes on it? The answer is, it depends. You have to file a tax return. Most trusts, the ones that I do, will say that the trust will pay the taxes rather than pass it on to the beneficiary. Sometimes it doesn't say, and so the trustee has to make a choice to pass it on. You have to pay capital gains if there are any. There's particular laws for people that are over, you know, I think it's 55, about capital gains taxes, so there's savings on those. So if the person that died was over 55, let's say, there wouldn't be a capital gains. But those kind of taxes would have to be paid no matter what. But it's not there's no inheritance tax per se, and in federal inheritance tax. In California, it doesn't have any inheritance tax. I can't speak to other states, but not the fact that it's an inheritance.
Excuse me, a couple questions related to the trusts. So I have some real property in a couple different states, and the successor trustee is here in California, but I established the trust document in Georgia. Does that all matter? What state you establish your trust
No, no. So you said the trustee's in California?
Yeah, the successor trustees in California.
Yeah, it's the state where the trust is being administered. That and as long as your other properties are in the name of your trust, you're okay. If they're not, then your trustee's going to have to probate that, or whatever they do in, let's say, Georgia, for example. So.
Right, but the fact that I established the document in Georgia, I'm a resident of California. All the properties are in the trust, and the successor trustee is in California. The successor trustee should be able to probate or whatever they have to do here in California.
Yeah, they shouldn't have to probate anything unless you lift anything up. They should be able to administer, yes.
Administer,
yeah, absolutely, yeah.
Okay.
It happens a lot, actually, where people they choose somebody from out of state, and it doesn't matter, yeah. It's wherever the trustee is, that's where it's being administered. Like you said, you're a resident and you're the trustee right now, right?
Right.
So right now the administration's in Georgia, but you know your successor would administer. And of course, right now the administrator is administering for yourself. So
right.
You know, yeah.
Okay, and then just following up on so if you have assets you're trying to protect, because I anticipate needing a high level of caregiving, and there goes all the money.
Yeah, yeah.
And so the irrevocable trust is the way to do that, where you move your assets in, well, you tell me.
Yes, yeah, it is, yeah, and so, now, one thing, like you're already anticipating, you know that you'll need a high level of care, because in some cases, people want to do irrevocable trust too early, and if you do them too early, of course, they're irrevocable, but I'm just guessing, your trust and your ultimate beneficiaries after yourself wouldn't probably be much different than your trust now, right? So you wouldn't be going, oh my gosh, I should have changed that. Yeah, so you would create an irrevocable trust, yeah, and you would transfer your assets to that. Now, in California, that doesn't, there is no look-back period for Medicaid or anything like that when you have them in an irrevocable trust. I'm just going to add, like, if you don't know what a look-back period is sometimes people start giving away their assets to all their kids. Well, Medicaid can actually look back 5 years to see what you had 5 years ago. There are things that you can spend down on, like prepaid funeral costs and things like that, life insurance policies, things like that. But just giving it away is not the way to go. So, Anyway, what was your question?
Yes, I wanted to know that when the difference between a trust and a will, it means essentially that some beneficiary will inherit assets or money.
Yes.
But in the trust, does that mean they don't have to, the beneficiary does not have to wait until the trustor, I guess the person who creates the trust, passes away? Is that true?
Well, the most common trust that most people have is a revocable trust, and the creator would be the trustor. Usually you run your own trust like you're doing, right? And you're the trustee and you're also the beneficiary, right? And so the people that you're leaving your estate to would be, we call them contingent beneficiaries because you really don't inherit until the time. But you can provide within your trust that somebody gets payments out of the trust at certain ages. If you want them to have it while you're living, you can do that, yeah.
I've heard of people who set up a trust fund for maybe their children's college education.
Oh yeah, that's a 529B account, yeah. That's different, that's done through the bank, and it's really nice because if the child would qualify later on for assistance, like financial aid, the 529B account doesn't count towards, they don't have to claim it as an asset, so it's a nice vehicle for that. And yeah, they would get it during college, yes.
So, back to the irrevocable trust, if you have a spouse,
Yes.
do they have to be a participant in that? Because, would that somehow eliminate them? Their assets need to be tied in to stop from the Medicaid thing?
No, there's special rules about spouses, but yeah, they don't have to go broke while their spouse is incapacitated, no. And are you in California by chance?
No, I'm in Nevada.
Is Nevada a community property state?
Yes.
Okay, so in community property states, a kind of misconception about community property is that it's all ours. Well, it kind of is, but you still have the right to do what you want with your half of the community property, and the spouse doesn't have to participate in that, so you do it that way, yeah. But there's special provisions and there's special agreements and things you have to have so the spouse is aware of the irrevocable trust. Another way to go is the special needs trust, because then that's a little more clear-cut, because then the spouse can fund that anytime they want.
So would the spouse's income and assets be part of this look back and, would count against your ability to qualify for it?
No, there's ways to transfer assets just to your spouse if need be, if you need to, yeah. Definitely needs to be done with an attorney and a financial planner though. Yes. You had another question back there? No? Oh, no? Okay, sorry.
Question?
Hi, I have a personal asset trust that is new to me, and I was told that it has asset protection, that if I were to become very incapacitated and, lost the house or something, they can't go into those funds.
Oh, and what state are you from?
Arizona.
Oh, okay, I was gonna say, it's not California, because we don't have asset protection trust, too bad,
Okay.
but yeah.
Well, it was set up in Chicago.
Oh,
and I'm in
yeah.
Arizona.
Yeah.
So, I've been told this is set up just for you. Don't change the way this is set up because you have all this asset protection. But it is also set up that if I passed away, the money could only go to blood relatives.
Oh, interesting, yeah.
So I would like to consider changing that, and after hearing about the special needs trust or the supplement needs trust.
That might be a better vehicle for you, yeah.
So is changing a trust like that a very difficult legal process?
Well, it's hard for me to know, because attorneys always say that, but we really literally have to read the trust and see what it says. It was created in Chicago or Illinois. I would recommend that you speak with somebody in Illinois or in Arizona, because you're in Arizona, and they can probably help you with that. So they're your assets that somebody set up for you, but they're very specific about. That's very interesting, because in California, we call it, you can't control property from the grave, which is literally what they're doing, like, no, blood relative. It's like saying only, the first son with purple hair can inherit the, property. Well, what if there is no son with purple hair? What do? You just can't do that, In California, I can't speak to the other state,
Okay.
so, yeah, that's what I would do.
Thank you.
Yes? Oh, she was gonna,
I'm sorry, I had
and then
another,
you.
I had another question.
Oh.
I have heard of trust funds that have been managed by law firms, and no disrespect to you, but the lawyer has stolen from the trust fund.
Oh.
What's again, no disrespect to you,
Yeah,
but
no.
what's to prevent that?
Well,
Because I'm from Philadelphia and I've read cases
yeah, I'm sure that that happens, yeah.
in the newspapers where that's happened. And what could be done to prevent that, an attorney from doing it?
Well, first of all, I don't think, in California, ethics rules for attorneys, they don't actually say you can't be a trustee. I actually am for one very elderly lady with no family, and she's, basically I paid her from her assets, I paid her dementia care facility. But it's not recommended to do it. I think the first thing is not pick an attorney. If you don't have a family member, I really would pick either a private fiduciary, bank, although banks are fussy about how many assets you have. They want high asset. There are some trust companies out there that are very good, and there are some, they're like they're corporate trustees. I would pick a professional if you don't have a trusted family member. Another thing to consider, even if, you know, your kids are great and you can just imagine doing that, that's fine, as long as you think everybody will get along. You're pretty sure, like with open arms. If they can't get along, don't pick one of your kids. I've had people pick like a distant nephew or niece or somebody they know has a good head on their shoulders but is not getting anything from the trust and has no interest in it. And if they're willing, I think that's a better thing. I think one thing that happens, there's a lot of, in California, well, in San Diego, well, I guess in California, because I do represent people in other parts of the state. There's a lot of discord with families, even with trusts. And I think a lot of it comes down to their choice of trustee. And everybody always thinks the trustee's not doing their job. And part of it is you don't know what's going on. You're not in the inner workings, you know, so you don't know. So anyway.
Yeah, my father had a trust. He died a few years ago. And part of the trust said that if any of the siblings fought the trust, then they wouldn't get anything.
Yeah. Yeah, it's a no contest clause.
Yeah.
Yeah, no contest clause. That speaks to the distribution, like you're contesting. It depends on the wording of the trust, but most of it is like if you don't, you know, let's say, I don't know, let's say there was somebody you didn't want to leave anything to and you said that. By the way, if that is the case, if you did have a child or a grandchild or somebody who just didn't want to get it, you should say that, and you should say why as kindly as possible. You know, you don't have to unload everything. Another thing is if you have somebody that is really not capable, like maybe they have an addiction problem or they just make bad decisions. You know, you can do one of the other trusts, especially within your trust, like a special needs trust, or you can, you know, if your trustee is agreeable, you can just have them dole it out in small enough increments that they can't cause too much trouble. But yeah, the no contest clause comes up a lot. And believe it or not, it gets contested a lot because, there's kind of like, what is a contest?
Does it hold up?
Most of the time, if they're drawn properly. So I guess nobody had contested it, huh? No. Yeah. So it was a good thing, yeah. So. Any other, oh, you had a question. Oh, yeah, she needs the,
She needs a mic. The lady up front needs a mic.
yes. Thank you.
Two things. One, I thought in Illinois, I thought that we had, I think it was $300,000 limit, so that when that passed to the children, that money was not taxable.
Oh, okay. Well, that's
And
good.
it did not have to go, not when we went to court.
Oh, that's good, yeah.
Now, when we moved to Texas, we had to rewrite our will. So
Mhm.
we left that in there, and I took it to a lawyer and they didn't question it, so I
Oh,
guess
good for that.
Texas must be the same.
Yeah.
The other thing is, we had property in Colorado and New Mexico,
Uh-huh.
and the state of Texas will not allow you to keep that in your will as a piece of property transfer to your children. So what we did was we sold them.
Oh, there you go. There you go. That's the way they're gonna
We'll
be.
fix them.
Yeah, you'll show them. Yeah, good.
No, this way.
Yeah.
Who else? Would you pass that down?
This is more of a curiosity question. I'm into genealogy. My great-great-grandfather's will, when it went through probate in 1851, 3 of the adult married children stated, for the sum of $1 in the love of my mother,
Mhm.
we hereby relinquish our interest.
Yeah, okay.
Is that something that still goes on?
Yeah, we call it, a power of appointment or a disclaimer. Like if for whatever reason you don't want to accept an inheritance, you can disclaim it, yeah. It has to be a written statement, and, given if it's a trust, you have to go to the trustee. If it's probate, it has to be filed with the court. Yeah, people do that, yeah. For all different kinds of reasons, you know, they have their reasons. Sometimes they don't need the money and they think their siblings or whoever will need it better. Sometimes there's just a bad feeling between whoever's leaving them the money, so, yeah, I've seen that, actually.
Any other questions? Yes,
I have a question.
sir. Wait.
A couple of questions. One is, my wife and I are in the process of updating our trust and updating, and I guess we have to get all our assets in the trust or that are funded by insurance policies or assets or property or cars or safety deposit boxes, whatever. All that has to be renamed, right? Or has to be, named properly, or.
Well, not everything, like retirement accounts, I would have a named beneficiary instead of putting it in the trust.
Okay.
Like the IRA that I mentioned, the
Right.
same, it is a retirement account, so, what else? Insurance policies, you can put the trust as a beneficiary if you want, or you can name individuals, either one, because in California, in most states, insurance policies don't go through probate. We call them paid on death or transfer on death accounts do not go through probate, so you don't have to put them in the trust if you don't want to. But if you bought property, sold property, real estate, or you changed banks, you should definitely use that to update your trust with.
And then how often, or what events would cause you to redo or amend the trust? Or how often should you, review the trust for, to keep it up to date?
Well, if there's like an event like a new child's born, or not that most trusts are word, let's say you're leaving something to your kids, or if they're predeceased me to their children or something like that. But it's always a good idea if you have, let's say, grandchildren come along, or somebody's adopted somebody, that would be an important event, or maybe require different real estate. People amend their trusts if it's been a while, and another thing that happens is the person you picked as your successor trustee dies, can't do it, they can't do it anymore, or you look around and you go, everybody I picked is the same age as me, I want to pick somebody younger, and something like that. Those are different reasons why sometimes people will actually either completely redo their trust, or we call it like restate their old trust. That usually occurs if it's been a while. Typically the ones I've done restated are like 15, 20 years old. Not that there's anything wrong with them, but a lot of times everything has changed in their trust, and an amendment would be an awful long amendment, so you might as well just, start from scratch, basically. And, I should say a restated trust means that the trust you had, you keep the same name, the same date it was created, and you're restating some things, but you're changing others. And then, of course, a new trust is just what I said, it's a new trust. So anyway.
We have time for 1 or 2 more questions.
I've seen ads where you've got things like the Susie Orman where she says, buy my CD to do your trust and your will and all that, or things online. What are the pitfalls of those, or the possible pitfalls?
Well, just speaking from my experience, I've had to redo trusts that were done on your own, you know, especially, I haven't had any experience with Susie Orman's, but LegalZoom, I had to redo a LegalZoom one. I had, this was before there were even programs. I had a gentleman, he wasn't my client, he passed away, and the two ladies that were named as his executor, or his trustees, I should say, came to me with a 300-page trust he made himself. And he listed everything he owned, and when I say everything, he had pictures too, like everything in his cupboard, which he put values to, and he had this idea that they would sit at a table with all the people he had named, and they would just start doling out money. Yeah. He owned a house, which wasn't in the trust. He owned vehicles, which weren't in the trust. So guess what we had to do? We had to probate the estate. So there are pitfalls. I mean, sometimes you can do them yourself if, you know, it's a pretty simple, straightforward thing, or you just want to get something done. I was just talking to Tony, who's assisting me, that I had a few people come to me that went to, so this might be something to kind of watch out for, people that, the one was called like the Family Trust Company was called. Well, the guy didn't say he was an attorney because he's not. He's a paralegal, and I looked him up, and he had come to San Diego from Arizona, but he wasn't a paralegal in Arizona. He didn't go to school for being a paralegal, and he was doing estate plans. And so they brought me their estate plan because they wanted to do it over. Like they weren't suspicious that anything was wrong. It was pretty bad, but the funny part was, I said, out of curiosity, how much did you pay for that? It was the same price that I charged, so I didn't, you know, I was like, I didn't say anything. I was like, oh, okay, well, and they redid it. But those kind of things you have to look for is people that are, and I'm not trying to, you know, like you were saying about attorneys, I'm not trying to slight there's great paralegals there. I use paralegals all the time, but if somebody's like setting up shop and saying they can do estate plans and they're not licensed to do that, I would be careful. Yeah, I mean it's okay to like get help with forms and things like that, but something like that's pretty important to do right.
Would mineral rights normally be included in the trust?
They can be, yeah. I've seen it both ways, yeah.
Okay, thanks.
So, one more question.
Can you recommend a lawyer up north?
Where?
Sonoma County.
I think I can.
Good.
Yeah, I
I'll
did.
check with you.
Yeah,
Right.
I'll give you my card, and you can email me or call me, and I have her name, I just not on the tip of my tongue. Yeah.
Thank you.
I'm sure Rosemary will be here for a few minutes. If you have one last personal question or whatever, you can ask her. Be sure to fill out your evaluation forms, and thank you very much.
Oh, you're welcome. Thank you, everybody.